This is the podcast series Creditors Corner Legal Talk presented by Smith Debnam, attorneys at law. Here we explore a range of legal topics impacting businesses and private individuals. So be sure to hit the subscribe button so you don't miss an episode. Again, welcome. My name is Garret Kirkpatrick. I'm an attorney in the firm's Consumer Financial Services section here at Smith Debnam, and I will be your moderator. Today's topic of discussion is pre- and post-sale deficiency notices and what creditors need to know in order to remain fully compliant with the Uniform Commercial Code in both North Carolina and South Carolina when sending these notices to debtors. So before we begin, I'd like to note that the information provided in this podcast does not and is not intended to constitute any legal advice. Instead, any and all information shared is just for the general informational purposes only. Listeners should contact their personal attorney to obtain any advice with respect to any particular legal matter. With that out of the way, now let's turn our attention to this week's topics of pre- and post-sale notices. So with us today, we have two attorneys, one in our North Carolina office, one in our South Carolina office. Our South Carolina attorney is Ron Jones, and our North Carolina attorney is John Sperati. So I'll introduce both of them in a minute. Ron is a partner in the firm's creditor rights and bankruptcy section and works out of our Charleston, South Carolina office. Say hello, Ron.
Hello.
How are you doing today?
I'm doing well, thank you.
Yeah. Also with us is John Sperati, a partner in our Raleigh office in the firm's Foreclosure and Creditors rights section. How are you doing today, John?
Doing well, Garrett. Thank you.
Yeah, of course. So today on this podcast, each of them will give a different perspective on the Uniform Commercial Code and the similarities and differences between North Carolina and South Carolina when it comes to these pre- and post-sale deficiency notices. We might as well just get right into it, and we will go to Ron for our first question. Again, Ron is in South Carolina, so he's going to be talking about the South Carolina Uniform Commercial Code and everything that has to do with these notices. So, Ron, first question: what are the requirements for a post repossession pre-sale letter in South Carolina?
In the consumer goods transaction, South Carolina Code annotated 36-9-613 requires a notice to the debtor with the name of the secured party and the debtor, a description of the collateral, the method of intended disposition, either by private or public sale, and a statement that the debtor is entitled to an accounting of the original debt and the charge for providing it, if any.
And so just briefly, if you could explain why do we have these notices? What are they intended to do?
Well, under the Uniform Commercial Code, one of the creditor's remedies is to recover the collateral for given as security for the loan, sell it in a commercially reasonable manner, and then apply that amount to the debt. That's the main secured creditor remedy provided in the Uniform Commercial Code all over the country. So in this situation, it requires that you give a notice after you've taken possession of the collateral, but before you sell it, to give a consumer debtor, in this case, all of the information needed and necessary to explain what's being done and what the secured creditor's rights are.
Great. John, are any of the requirements for these pre-sale letters after a repossession any different in North Carolina from what Ron had said?
But like most things involving the Uniform Commercial Code, they are very similar. And so what we would look at is there are some additional requirements when the debtor is a consumer. And a consumer transactions under North Carolina General Statute 25-9, 613, and 614. It requires the debtor's pre-sale notice to contain, first, the information under 613 is the identification of the debtor and the secured party, a description of the collateral that is subject of the sale or potential disposition, the intended method of the disposition, whether it be a public or a private sale. It must state that the debtor is entitled to an accounting of unpaid balances, the charge, if any, to obtain that accounting, and the identification of the time and place of a public disposition, or in the event you're using a private sale, the date after which any disposition will be made. And then from 614, this is specifically dealing with only consumer goods, a description of any liability for deficiency of the person to which the notice is being sent, a telephone number from where the debtor can obtain information from the secured party about how they may redeem the car, meaning how much they can pay to get the car back, or also a lot of times what they have to do to get personal property out of the vehicle if they had some in there when it was repossessed. And then lastly, the telephone number or mailing address, which the information concerning disposition, obligation, secured, available, can be obtained. Excuse me.
Great. John, does this statute require any specific language when it comes to these notices?
North Carolina statutes do not require any specific particular phrasing, but it does provide sort of a potential form to be used. We encourage all of our creditors to use that form because it is easier to demonstrate that you complied with the statute. 613 further references just as long as the creditor provides the information that we just discussed, the notice will be deemed sufficient, even if some of the additional information is provided or if there are minor errors included in the notice, as long as it's not significantly misleading.
Ron, what about South Carolina? Does the South Carolina statute require any specific language for these notices?
In a word, no. The statute requires that the notification provides information required, as we discussed earlier, and it's sufficient under the statute, even if it provides additional information, as John had said in South Carolina, and any additional phrasing, however, is not required, and minor errors are allowed so long as they're not misleading. Form notice in subsection 5 of the South Carolina UCC, and it provides a form notice which is defined as sufficient for purposes of the statute if you use it. If you use that specific notice known as the safe harbor notice, then it is deemed sufficient on its face, and for that reason, that's the best way to go.
Now, you said that's the best way to go. In some of your experience, what are some of the issues that can come up if creditors are, just writing whatever they want instead of trying to go, based on the safe harbor notice? Are there issues that arise when a creditor wants to use their own language or try and state things in their own way?
There could be. If you use your own language or add additional information, then you're going to have to demonstrate as the secured creditor, if the issue comes up, that the information you gave is sufficient under the statute. If you use the statute itself, it's deemed sufficient on its face. Use the form letter in the statute itself, the safe harbor letter in the statute of itself. So what happens generally in these cases where you add a lot of additional information and you don't follow the safe harbor letter word for word, then there could be an issue that arises as to whether or not it's sufficient information given that complies with the statute and that is not misleading. So either one of those things could become an issue in a case on behalf of a consumer debtor angry over the repossession of its collateral, be it a car, a boat, or whatever it is.
Now, again, this one's for you, Ron, to talk about South Carolina. So after the repossession happens and the creditor goes ahead and sells the thing that they are repossessing, what notice is required to the debtor at that point after the goods or whatever the thing is has been sold?
Well, in order to meet the commercially reasonable requirement under the Uniform Commercial Code, you're required to give notice after the sale sufficient to inform the debtor of the outcome of the sale, whether there's a surplus or a deficiency. South Carolina Code annotated 36-9-616 requires a notification that includes the amount of any surplus or deficiency after the sale of consumer goods, which provides an explanation of how the surplus and deficiency was calculated. The statute specifically requires that the aggregate amount of the obligation secured by the security interest under which the sale was made, and if the amount reflects a rebate of any unearned interest or credit service charge, those credits must be there listed. Second, the amount of the proceeds of the disposition or sale. Third, the aggregate amount of the obligations after deducting those proceeds. The amount of the aggregate or type of expenses of the sale related to the sale. The amount of the aggregate or type of credit or rebates of interest, credit service charges to which the debtor is entitled, and the amount in the end, the net amount of any surplus or deficiency.
Great. Now, John, how does this differ for North Carolina? What does North Carolina require after the disposition or sale of the goods by the creditor? How does that notice play out in North Carolina?
As I said earlier, like with most things with Uniform Commercial Code, they're very similar with a few differences. Under North Carolina General Statute 25-9-616B, it requires a consumer-related transaction in which a debtor is entitled to a surplus or a consumer obligor is liable for the deficiency, which is defined under 25-9-615. The secured party is required to give notice with an explanation of the calculation before or when the secured party accounts to the buyer or pays any surplus or first makes written demand on the consumer obligor for payment of the deficiency. And that must be done shortly thereafter or within 14 days of a written request to send the notice or provide a waiver of a deficiency. So that notice is required to have, like Ron talked about in South Carolina, the aggregate amount of the obligation secured by the security interest under which the disposition was made, and if any amount reflects a rebate of unearned interest, credit, service charges, an indication of the fact, calculations, and the specific dates, the amount of the proceeds of the disposition, the aggregate amount of the obligation after deducting the amount of the proceeds, the amount in the aggregate or type and types of expenses, including your expenses for retailing, holding, preparing the thing for disposition, processing and disposing of the collateral, attorney fees secured by the collateral that are known to the secured party and relate to the current disposition, the amount and the aggregate type and types of credits and rebates and interest and credit service charges that were given or which are not reflected in that first subdivision 1, and the specific amount of the surplus and the deficiency. So it's a wordy way of saying they're almost the same.
So, John, in your experience, what are some of the issues, the pitfalls that arise when creditors, fail to provide this notice entirely, whether they, fail to provide the deduction for the amount of the proceeds, whether they fail to provide certain expenses, things like that? What are some of the issues that arise with this post-sale letter for creditors?
The most common failure that we see is failing to either timely provide the notice or to provide it at all. And at that point in time, if contested, you're more than likely going to get a judge that's will say that you've been deemed to have waived your right to a deficiency judgment against the obligors, especially in a consumer transaction. We'll discuss it some more. There are some provisions. You have some minor errors in there. Okay. But the primary thing is providing it and making sure it's accurate. In some instances, if you are providing a substantially incorrect amount or either one way or the other, it could be deemed to be misleading. And again, would be a waiver of your right for a deficiency.
Now, we have already discussed just briefly, that there are these safe harbor notices in the Uniform Commercial Code. Ron, is there a safe harbor notice associated with this post-sale letter that goes out by the creditors?
No. No particular phrasing is required, and there's no form letter to be used as there is in the pre-sale notice. But if the notice substantially complies with the listed requirements, it is sufficient. As you can imagine, that leads to a lot of issues and discussions and become issues and discussions in litigations. It may be a good idea to include in the disposition letter that the debtor may be liable for fees and costs related to a subsequent lawsuit to obtain a judgment for any deficiency. But again, as John pointed out, minor errors don't matter. Sufficiency is what matters. And of course, determining what is sufficient sometimes is the very essence of the litigation itself. Finally, the statute does also allow a consumer debtor to receive an explanation of the secured accounts without charge within a 6-month period. Thereafter, the secured party may charge up to $25 for each explanation. I've never in my practice had either one of those two elements become an issue. It's usually over, as we talked about earlier, sufficiency and whether the minor errors, if any, were misleading.
Now, what are some of the things that, we see with the phraseology, such as, having to put in there for attorney's fees, and, maybe there haven't been attorney's fees that have actually been expended at that point when the post-sale, notice goes out. Are there things that creditors should think about when putting in their, sending out these notices in order to, I guess, just cover all their bases?
Well, yeah, I've had it come up before, particularly in situations where the vehicle is peacefully repossessed without a lawsuit, and there's been no real action except by the secured creditor to recover the collateral. The costs there are relatively easy to determine. They're whatever you paid the third party you used for the repo fees, any storage fees, any fees and commissions for the sale if you did it by public sale or private sale through an auction or something like that. Those are relatively simple. The issue that has come up a couple of times when you sue later on the deficiency is that some debtors claim, well, you didn't give me any notice and tell me that I might have been subject to attorney's fees in a subsequent action on the deficiency. I don't think the statute requires that, but that's an issue that comes up occasionally. And the result of the one that I was involved in that was arbitrated, the arbitrator declined to allow fees because it wasn't in the notice that the debtor might in the future incur them. I don't think the statute requires that, but the arbitrator found that they did. So that's why I had said, and I think it's a good idea, that when you're doing it and you're talking about future costs, that you include that there might be costs related to a lawsuit to recover any deficiency.
John, is there any safe harbor notice or particular phrasing required in North Carolina, or is it, again, pretty similar because it's the Uniform Commercial Code and many of the states are similar?
You hit it right on the head. There is no particular phraseology required or form. The statute does specifically refer that as long as you're providing a notice that substantially complies with the two statutory provisions, that is sufficient, even if it includes some minor errors that are not seriously misleading to the debtor. And so there is no real safe harbor provision, but it also leaves a lot of wide berth for how you arrange for your notice and what it provides for.
So in your opinion, I guess, why are these important, John? Why are these notices important? Obviously, the easy answer is that they're required, but what is the main takeaway for why creditors should be careful, why they should, scrutinize these letters when it comes to sending them out pre-sale and post-sale? What is the general aspect of why these letters are required?
The primary purpose is to provide the debtor with clear information on one, if there is a surplus or a deficiency, and when they can expect to have either the money come or the liability, but also to give them notice of all your fees and costs and things of that nature. And it also, I always say that it's just proper accounting, because also it's been the nature within the auto industry, as a lot of these add-on services come along, that when a car gets repossessed and the owner or the debtor had purchased at the time of purchase a warranty, a service contract, some sort of other service that was used up on a monthly basis after they paid for it, there is a refund for those, and they can take a while. So I always like to have in there a provision, sort of kind of like what Ron referenced, that there may be future attorney's fees, and there may also be future credits, because if there are some significant credits come in, we see it very commonly, especially when a car has been repossessed within the first year. Some of those service contracts and extended warranties are fairly expensive. So there can be some sizable refunds that come along, but they're going to come a year later. And so we may have to send out another notice updating the information. So all we really want to do is preserve our right to a deficiency. I have a lot of clients who have no interest in pursuing a deficiency, but I always caution them to at least attempt to preserve it, because it costs you really nothing other than a letter and 15 minutes of time to fill in the information out of the file, so that at some point in time you do want to pursue the deficiency, you can do that.
Ron, anything to add about the importance to these pre and post sale notices?
Well, John hit it right on the head. That nail right on the head. That's exactly the purpose of them. There are some issues that modern car sales in particular have that weren't around at the time that the code was written. So these future credits are as important as future liability for like fees and costs, and you got to keep those in mind. The underlying theme under the Uniform Commercial Code in exercising the remedy of liquidating collateral given for the loan is that any sale or disposition of the collateral be commercially reasonable. And these statutes, I believe, are designed to be sure that the proper notice is given of the attempt to sale, and then after the sale, how the proceeds were applied to the debt or obligation, resulting in either a deficiency or a surplus.
Right. So the takeaway is make sure that your notices are up to date, and as the law changes, as the UCC adds things, takes things out, that you're talking with your attorneys and making sure that these notices are going out on time and with the correct language, with all the things included that need to be included per the code in each state. Do either of you, John, Ron, have anything else that you want to add or talk about?
No, just thank you, Garret, for taking the charge on this thing, and and helping us get this podcast out. We appreciate the opportunity to be involved.
Of course.
And I'll echo the same. Thanks for doing this, and thanks for your assistance. And I believe we've about covered. It's a fairly short subject, but it is an important subject.
It is. And thank you both for participating, and thank you to the audience for listening. And if any of you listening do have any questions, feel free to email or contact either of the speakers. John, what's your email address if they want to send you a question?
It's J Sperati, and that's SPERATI at smithdebnamlaw.com. And it is on I think all of our emails are on our webpage.
Yeah, I think so too. Ron, just for listeners, what's your email in case they do want to reach out?
Sure. rjones at smithdebnamlaw.com.
Awesome. Yeah, and thank you to all of our listeners. Please check out our other episodes that have already been recorded, and I'm sure will be recorded as we love to do these and keep informing everybody on the current issues and the ever-changing aspect that is the UCC and the law and creditors' rights. And remember to subscribe, and everyone stay well and have a good rest of your week. Thank you.